Okay, thank you, Lizzie. Um, Homeowners associations. House Bill 1203 was the major vehicle for amendments to Chapter 720 that impacts HOAs. So if you're in a condo and you don't really and you don't care about HOAs, you can kind of go and grab your favorite beverage, and I'll holler at you when we get to the condo portion of the presentation. Um, a lot of changes affecting official records if within an HOA. Effective January 1st of 2026, if you have more than 100 parcels, you have to maintain a digital copy of a whole list of records on your website or through an application on a mobile device. The statute has been amended to include the extensive document list for you. Good news is, if you fall within this category, you have some time until the beginning of January of 2026. If you get a subpoena from a law enforcement agency, you have to make the records available within 5 days. You have to maintain the records for at least 7 years unless the governing documents have a longer period of time. And if you're in an HOA, you are now required to adopt rules governing the retention of your records. So that's something you need to discuss with management and/or counsel. Criminal penalties. Yes, there are now a lot more criminal penalties, I should say, for board members within an HOA. It's now a second-degree misdemeanor for any director or member of the board to knowingly, willfully, and repeatedly violate any specified requirements related to inspection or copying of official records with the intent of causing harm to the association or the members. Now, what is the intent of causing harm? We don't know. And you're going to hear me say that a lot during the presentation tonight because there are a lot of changes and there's a lot of ambiguity, a lot of inconsistency, and a lot of the issues are going to have to work its way either through legislative amendments for next year or through courts or through the division. But the intent of causing harm, if you violate the records inspection, it could be a second-degree misdemeanor. It's a first-degree misdemeanor if you destroy records with the intent of causing harm. Third-degree felony to willfully and knowingly refuse to release or otherwise produce association records with the intent, not of causing harm, but to avoid or escape detection, arrest, trial, or punishment for the commission of a crime. The fact that all of you folks are on this call means that this is probably not going to ever apply to you because you care about following the rules and the laws that are in front of you. You're not going to be trying to destroy records to avoid or escape detection or arrest. It's a felony to accept a kickback. It's a first-degree misdemeanor for knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity. And if you're charged with a criminal violation, you're removed from office and a vacancy is declared. Financial reporting. 720 has now been amended to require all associations with 1,000 or more parcels to have audited financial statements, regardless of the amount of your revenue. So if you have $300,000 in revenue, you're required to have an audit performed every year if you have 1,000 or more parcels. And if you're one of those communities that always waives your annual audit, you can't do that 2 years in a row. So every other year, you'll now have to have an audit performed. A quirky change to 720 is there's a whole procedure now for individual owners. This is separate and apart from the estoppel certificate, but for individual owners to make a written request for a detailed accounting of any amounts owed to the association. Essentially means a ledger, which would include any fines that are due on their account. The consequence for not providing the detailed accounting within 15 business days, which is a pretty long time, is that any outstanding fines are waived if the fine is more than 30 days past due and the association did not give prior written notice of the imposition of the fine. If you're scratching your head with that, a lot of us are too, because it's confusing, but this is the way the language is written. But essentially, provide the parcel owners with the detailed accounting, including fines, within 15 business days. And once you do that, they can't make another request within 90 days. if you're a Green Acre association, you log on to your portal, and that's going to be your detailed accounting. It's going to be there for you. Education. It's very different for HOAs versus condos. And we're just talking about HOAs now, because it requires, if you're in an HOA, it requires a newly elected or appointed director within 90 days to submit a certificate having completed a course. And you have to do this course every 4 years. It requires, has certain requirements as far as what it needs to include. It's that typical board certification course, but more. And in addition to the board certification course, you're required to have at least 4 hours of continuing education annually if you have fewer than 2,500 parcels. If you have more than 2,500 parcels, 8 hours of continuing education annually. And by the way, you're still a volunteer. This means, based on this new language, if you're on the board right now, this statute became effective July 1st. So if you were elected prior to July 1st, the 90-day requirement of submitting the certificate does not apply to you, because it requires a newly elected or appointed director to do this. If you are not if you're elected now, if you're elected today, you have 90 days to complete that. But however you look at it, you still have to have 4 years of continuing education annually. And we'll talk about what courses and what information has already been approved by the division, because the Division of Condominiums, Timeshares, and Mobile Homes that comes out with who's an approved provider for certain types of courses, they're still wrapping their arms around everything, and they haven't approved anything to my knowledge at this point in time for these continuing education requirements. So what I've been telling all my clients is sit tight for 30 days, 45, 60 days, and see what's being offered. Sure, a lot of management companies are going to be providing certain types of courses. Lawyer's office, including my own, will be providing courses, but just stay tuned, because everything is so new to everyone right now. Enforcement. The bill amends Section 720 to require an architectural control committee to provide written notice of the rule or the covenant that's relied upon when you deny a request. This is important. You can't just say we don't like it. If it's because it doesn't comply with the harmony of external design, then you need to cite the specific section of the documents in your denial when you issue such denial. You can't place limits on the interior of a structure or require review of HVAC, refrigeration, heating, or ventilating systems if it's not visible from the parcel's frontage, adjacent parcel, common area, or golf course, essentially all around the lot. You also can, and this is going to seem silly, but the statute now says you cannot prevent a homeowner from installing or displaying vegetable gardens and clotheslines in areas that aren't visible. Why would they say installing or displaying vegetable gardens? Why not just say planting? So can you plant a vegetable garden if it's not the installation or display? Don't know. This is what the language provides. And just to handle a couple questions that are coming in as they're coming in, the 4-hour training, I believe it's going to start for this year. So by the end of 2024, you'll have to have that 4 or 8 hours of training, unless there's additional guidance from the division. And as far as audited financial statements, if you have 1,000 or more units, you have to have an audit done every year. If you have fewer than 1,000 units, 1,000 homes, lots, it depends on your level of revenue. Fines and suspensions. A lot of you are going to be scratching your head by the end of this and not wanting to fine or suspend folks anymore, because it's even more burdensome now than it has been in years past. So 720 was amended to require 14-day notice to be in writing to the parcel owner. Almost all of you folks who are doing fines are doing that. It requires the hearing to be held within 90 days of the notice. The committee is allowed to hold the hearing by telephone or other electronic means like Zoom. But the information for the electronic meeting has to be in the notice. And here's something new. No fine or suspension if the violation is cured prior to the hearing. So if somebody is getting a fine for not cleaning their sidewalk, and the day of the hearing, they go and they clean their sidewalk, even though you've gone through all this effort and all these notice requirements and everything else, no fine or suspension can be confirmed against that person, which also means you need to confirm whether it's been cured prior to the hearing, the day of the hearing. After the hearing, written findings have to be provided within 7 days. And here's strange language that's now included. Such notice must include the manner in which the person may pay a fine, cure the violation, or fulfill a suspension. Fulfill was a term that the legislature used. I'm not really sure what they mean by that, but that's what they put there. In that notice that you send, it requires the date by which the fine must be paid to be at least 30 days after delivery of the notice. And fines or suspensions may not be imposed if the violation is cured after the post-hearing notice. So here's the strange part of all of this. There's no distinction between continuing fines and one-time issues, such as a continuing fine is the cleaning of the sidewalk, whereas a one-time issue is the party that created a nuisance in the neighborhood. Can you cure that one-time violation of the party in the neighborhood? Probably not, right? If you push somebody, you can't cure that. You've pushed them. It's over. It's done, right? And that's the way a lot of folks are interpreting that. That continuing violations can be cured. Non-continuing violations, they're not capable of being cured. How is a court going to interpret that? We'll find out. The bill, as far as prohibitions on fining or suspensions, as I said, if things are cured before or even after the fining committee hearing, cured after the fining committee hearing, then you can't fine them. Leaving garbage receptacles at the end of the curb or driveway less than 24 hours before or after the day or time of garbage collection. So if you have 2 days of garbage collection, that could be 24 hours before one day, 24 hours after another, and then you're right back into 24 hours before the next. That means 5 or 6 days a week. You can't issue a fine for that. You also can't issue fines for leaving holiday decorations or lights up longer than indicated in the documents, unless you give folks a 1-week notice. All right. Parking. This is an issue that if any of you are watching the news, you'll see that this has been an issue that's been reported on. A few different associations are pushing back on some of these parking restrictions that are contained within 720 now. And it says that associations may not prohibit a homeowner or others from parking a personal vehicle, including a pickup truck, in the owner's driveway or in any other area where they have the right to park under applicable governmental provisions. A work vehicle, regardless of any visible lettering identifying the vehicle, which is not a motor vehicle as defined in section 320.0525 of Florida statutes. Now, what does that mean, a work vehicle? Because you may say, oh, commercial motor vehicle. We can still prohibit that Banco garage door truck or the plumbing truck that's in our neighbor's driveway. No, you can't. Because a commercial motor vehicle, as defined in that statutory section, is a vehicle that weighs more than 26,000 pounds and takes special fuel or has multiple or has more than 3 axles, it's a big commercial vehicle. So your standard vehicles with commercial lettering, you now can no longer prohibit folks from parking those in your community. Now, there are some firms out there that are taking the position that if you have certain language in your governing documents or the absence of certain language in your documents, that this statutory provision does not apply to you. If you're looking on, if you're Googling it and searching for it, the recent news articles that have come out, they refer to what's called Kaufman language, which is the name of a case that came out a number of years ago that says, if you have language in your documents that says, we adopt the act, this chapter 720, as it exists on the day hereof, and as it may be amended from time to time, if you have that language in your documents, these new restrictions will probably apply to you because you're adopting changes in the statute. However, if your documents are silent, or if they just say the act as it exists on the day hereof, then this language might not apply to you. And how do you deal with that? A court's going to have to reach a determination ultimately, and there are already several large associations that will be teeing up some cases throughout the state dealing with this very issue. But this is a change that's going to create a lot of problems within communities. And Jennifer, as I'm going through, if there are questions, just if you want to interrupt me and pepper them, then we can do that.
Okay.
But I know there's so much content that I'm going to try to respect everyone's time and go through them. So if I don't answer any questions, you can of course reach out to me or to Jennifer in the coming days to have those questions answered. Okay. Electronic voting. The bill, and this is a helpful change. The bill allows members of an HOA to consent to electronic voting electronically. So instead of completing a paper form, you now can actually get communication from management or from the association that says, if you want to opt in for electronic voting, click here and complete a form online. That's okay now. For assessments, only simple interest, not compound interest, is allowed to accrue. And for managers, all managers are required to annually attend at least one member meeting or board meeting of the association. I'm sure your managers are already doing that. A lot more than just one. And management companies are required to provide members with certain information, including the contact person for the management company, contact information, hours of availability, and a summary of the duties. You're required, management companies are required to provide a copy of the contract between the association and the management company upon request of the owners. And unless you've been practicing more than 10 years as a manager, you're required to complete at least 5 hours of continuing education that pertains to HOAs, 3 of which relate to record keeping. That's the end of House Bill 1203. As I said, that's from a high level, but there are other bills that there's more detail, and there are other bills that pertain to HOAs, including House Bill 59.
Aaron, before we move into that, would you like to answer a couple of these questions based on that section?
Yeah, sure. So I'm going into this, and I see a question about if someone has done a project that requires an ARB application and did not submit the application, is there a timeline the HOA has to have the person receive a violation for not sending in an application? Hi, Judy. I see that question is from you. There's only a timeline if your governing documents require it. A lot of governing documents will require the association to take action, or if something is known by the association and they don't approach it within a certain period of time, then it's deemed approved. But that is very document dependent. There's another question about an interpretation of Florida law several months ago required the community board to approve all ARC requests. It's created some practical difficulties, seems to require more board meetings. The new law does not deal with or address that. A lot of associations have ARCs, and the ARC they do approve the applications. It also depends on your documents, whether you have an ARC, whether the ARC is an advisory subcommittee, or has the power to approve the ARC applications. And there's a question about legal fees incurred related to the violation. Can we assess that? Unless, and this is pertaining to fining, if the person has not cured or fulfilled the issue within that 30-day period following the adoption of a fine, there is language in the statute that permits recovery of attorney's fees, but not until after that point in time. So as you can see from all the different changes dealing with fining, it's not that palatable to fine anymore for all those reasons. And many associations are taking the position that we don't have to fine, we can take enforcement action against owners, such as moving forward with pre-suit mediation demands. And there's no requirement for a fining committee. There's not all of these hurdles you have to jump through and jump over. So a lot of associations are considering whether it's even worth it to fine anymore. Let's see.
We have three at the bottom about parking.
Yeah, as far as parking, parking rules different behind the gates in HOA-owned property. No, they're not. This talks about it. This is not a distinction between public and private roads. This is what language you're allowed to have in your documents, and as we talked about, it depends on whether you have Kaufman language or not. And we will see a court case in interpreting that at some point within the next year to 18 months, unless it's cleaned up by the legislature. All right, we'll go ahead and move on. House Bill 59. This is it's just one issue pertaining to this bill, and this just wants the legislature wants all HOAs to provide copies of all the rules and covenants to every member. They want everyone to know what the rules are. So prior to October of this year, every homeowners association is required to provide a physical or digital copy of the rules and covenants to every member of the association. And you have to continue to do that for every new member. And if you amend it, you have to continue to do that for every amendment. Now, if you have a website, you can fulfill this requirement by posting a complete copy of all the rules or a link to the rules and sending the owners notice telling them that the documents are on the website available for download or for viewing. You still have to send that notice to everyone within the community. That's something that you should, if you have a membership meeting coming up, if you have an annual meeting, a membership meeting, a board meeting that requires a membership vote or a longer notice period between now and October, incorporate that notice directing folks to the website. If you have a website, if not, make sure you get the governing documents sent out. Okay. House Bill 293 is effective. It was effective back in June. They're all effective now. Adds a whole new section dealing with hurricane protection. Hurricane protection, there's a whole new section that it requires each HOA to adopt hurricane protection specifications for all structures governed by the association. You can include color, style, and any other factor you deem relevant. Once you adopt these specifications, the board or the ARC cannot deny an application for installing hurricane protection unless it fails to comply with the adopted specifications. So it's important to be detailed in your specifications. And hurricane protection is widely defined to include roof systems, permanent fixed storm shutters, roll down shutters, impact resistant windows and doors, different types of panels. There's a whole laundry list of items of what is considered hurricane protection. So I encourage you to make sure you have hurricane protection specifications detailed out. And I know there was one more question in here about proxies, to designate a board member as a proxy to vote for them at meetings, including voting for director elections. There's nothing with respect to that in the new statute. The new statute doesn't mention anything or change anything with respect to proxies. Generally speaking, directors cannot vote by proxy during board meetings. That's the general rule of thumb. And that is it with respect to HOAs. So everything else we talk about is going to pertain to condominiums. So if you're in an HOA and none of that bothered you too much, you have pretty thick skin. But you can, of course, pay attention to the rest of the presentation, but take everything with a grain of salt because it doesn't apply to you unless you also own a condominium. So the first bill pertaining to condos is House Bill 1029. That was called the My Safe Florida Condominium Pilot Program. And the whole purpose of this is to provide inspectors to perform inspectors and facilitate grants to certain associations. To be eligible, you have to be within 15 miles of the coast and have to receive a majority approval of the board, or the total voting interest of the association even participate in the inspection. The purpose of this is to determine whether you can engage in any kind of improvements to your building that could be subject to a grant by the state of Florida. If this is something you're interested in, speak to your lawyer, speak to your manager right away, because there's a very small bucket of money that has been allocated towards this across the entire state. So at this point, if you haven't already applied and you're not familiar with this, you may be too late, at least for this year. But I just wanted to bring that to your attention in case this would be something that would be helpful to you. House Bill 1021 was the major bill impacting Florida condominiums, and there are a lot of changes, and we're going to jump in and talk about them. Milestone inspections. The only change dealing with milestone inspections is now it exempts 4-family dwellings with 3 or fewer habitable stories above grounds. Prior to this statute, single-family, 2-family, and 3-family dwellings were exempt, but now it's also 4-family. Official records. Different changes from HOAs. Now it provides that if records are lost or destroyed, there's a good faith obligation to obtain and recover the records as soon as possible. So now if you transition to new management, if you transition to a new bank, and you don't have those records anymore, you have a good faith obligation to obtain and recover them. That means you just can't sit back and say, well, there's nothing I can do. You have to do what you can to get all those records and document your efforts. Email addresses can now be accessible to unit owners if those owners have consented to receive notice that way. You are prohibited from selling or sharing information to third parties. And effective January 1 of 2026, if you are in a condo that has 25 units or more, you now have to have a website with a whole list of records available on the website for download. So it used to be 150 units. Now it's 25. It's a lot more. It's a lot more, and it's a big burden for smaller communities to have to budget for and activate a website. If you don't provide records to an owner and they complain to the division and the division subpoenas the records, you can't charge the owners for them. And you have to maintain additional financial records now, which includes invoices and any other documentation that substantiates any receipt or expenditure. So any receipt for any amounts that are spent, you need to have records of it. And here's a significant change. Require associations to respond to records inspection requests with a checklist of all records that were made available for inspection and copying, and identify any records that were not made available. What does that mean? How granular do you have to be? Statute doesn't say. Does that mean you can say financial records? Check, we've provided them all. Maybe. Does that mean you have to do 2024 financials? April, May, June, July, August financials? How granular? We don't know. We'll have to see how the division interprets this. I'm hopeful that the division comes out like they have in the past with sample forms for best practices, because that will be very indicative of what they're looking for and what they will take issue with if an arbitration action is filed or complaint is filed with the division. So that's something that every records inspection request now, you have to provide a checklist of what you've provided, what you haven't provided. And if there's a complaint made with the division, you have to allow the division to access all the records on your website. Criminal violations. There's now a whole list of items that it not only includes board members in this bill, it also includes managers. That the same issue with respect to knowingly, willfully, and repeatedly violating requirements related to inspection or copying of records. If you do 2 or more within a 12-month period, it's a second-degree misdemeanor. First-degree misdemeanor to knowingly and intentionally deface or destroy accounting records. Third-degree felony to refuse to release or produce association records with the intent to avoid detection, arrest, trial, or punishment. Can't accept a kickback. Obviously, if you engage in fraudulent voting activity, it's a first-degree misdemeanor, and there's a whole list in the statute of what is considered a fraudulent voting activity. Budgets. As with HOAs, you cannot reduce the required type of financial statement for any 2 consecutive years. Okay. Section 718.112(2)G was amended to require associations to provide unit owners with a notice that the SERS report is available for inspection and copying within 45 days. And you have to also notify to the division within 45 days after the SERS is completed. If any of you are in the unfortunate circumstance where you have a natural emergency or the building is rendered uninhabitable, then you don't have to fund reserves. I guess that's helpful. And now the annual financial report has to be mailed, emailed, or personally delivered to each owner, and you cannot just tell them that the report is delivered upon request. Now everyone has to get a copy of the financials. Meetings. If you have more than 10 units, you have to meet at least quarterly. And at least quarterly, the agenda has to allow members to ask questions concerning the status of construction or repair projects, revenues, expenditures, and other issues affecting the condominium. So I know for all of the board members out there, you take the position, and rightly so, this is not on the agenda. We're not discussing it during this meeting. That will work for your monthly meetings, with the exception of the 1 quarterly meeting where you have to allow owners to ask questions. So at least quarterly, you should have an owner forum on the agenda to allow all these questions to be asked. That doesn't mean you have to have the answers. And if you don't have the answers, you can tell them either we will look into it and we'll get back to you, or you can ask the owners to submit a written inquiry by certified mail as set forth in Chapter 718, and then it'll give you 30 days or 60 days if you need a legal opinion in order to respond to those questions. Any meeting where you're going to be discussing assessments has to include the estimated cost and description of the assessment, as well as the purpose. And here's a strange change. If an agenda item relates to the approval of a contract, a copy of any proposed contract must be provided with the notice, and it must be made available for inspection and copying. Well, what happens if you post your notices in a bulletin board that is like locked with glass? You have to post the contract so it looks like folks are going to be able to see the first page. If you have a website, you'd post the proposed contract on the website. But this is a change within the statute that, as of now, everyone has to follow. Director Education. As with HOAs, you can no longer just sign the form and say that you have read and understand your documents. There's now a requirement for a board certification course for both HOAs and condos. And to satisfy your educational requirement in a condo, you have to do an educational course, a board certification course that's at least 4 hours long and includes instruction on milestone inspections, SIRS, elections, record keeping, etc. If you are an existing director appointed prior to July 1, you have until June 30th to complete that 4-hour course. If you're elected tomorrow, you have 90 days to complete the 4-hour course. Annually, in addition to this 4-hour course, you have to do at least 1 hour of continuing education about recent changes to the laws and rules during the past year. And as far as these courses go, I have a 4-hour long course that I've communicated with the division about because I am an approved provider. I've asked what I need to do, and a lot of lawyers have asked that. My understanding right now from the division is that anyone who was an approved provider may not be an approved provider. The division needs to put a whole system in place in order to start approving new providers because of the new changes, the 4 hours long, and the different types of requirements that are put in place. This is information I've heard secondhand. The division, I'm still waiting for the division to get back to me on what I need to do in order to ensure that when I teach a board certification course, it counts. But for now, no one really knows. So this is one of those things where be patient over the next 30 to 60 days. I'm sure more information will surface on who is approved, what needs to be done, etc. Voting. Now, in a condo, if you're going to suspend someone's voting rights due to non-payment of a fee or assessment, you have to do that at least 90 days before an election. So your notice of intent to run for the board goes out 60 days before. But at least 90 days, you have to suspend people's voting rights. So if somebody is delinquent and ineligible to, or previously ineligible to vote, at the 30-day mark, you cannot suspend their voting rights because it's not at least 90 days before an election. As with HOAs, in condos, you can now consent to electronic voting electronically, which is helpful. Hurricane protection. This is a big change for condominiums. And the information here is one slide, but it's a lot more in depth. And if you're in a condominium and in the process of an exterior project, you need to consult with your lawyer on what to do and how to handle it. And I'll tell you why. Not only are you required now to have delineation in governing documents about who's responsible for what when it comes to hurricane protection, to have a procedure put in place for approval of hurricane protection, but if the association removes hurricane protection as part of an exterior project, say you're fixing balconies, you have to remove the hurricane protection. The statute now says that associations are responsible for the removal and reinstallation of that hurricane protection. Well, what happens when you remove the shutters and they can't be put back up because they're not code compliant? Statute's unclear on that. It just says removal and reinstallation. the advice I've been providing is you got to think long and hard about how it's going to look in court. If you remove someone's hurricane protection, you don't reinstall it, and someone suffers hurricane damage, when you are required, and the intent of the statute is to leave that owner protected when you stop work on the outside of the building. It seems to suggest from the language in the statute that if you remove hurricane protection, you're responsible for making sure the owner is protected, which may include purchasing at the association's expense code compliant shutters. That can be a significant cost. So this is something to discuss with your engineer, with your contractor, about certain steps to take to avoid removal of certain hurricane protection if you can. It's a big change because it has significant financial impact to a lot of associations. So we want everyone to be aware of that. Managers, you're now required, if you sign with Greenacre, you come over, your prior management company is required to return all business, all records, all official records within 20 business days of the termination of the services. There's civil penalties and license suspension potentially for noncompliance. And there's also a whole new section that deals with conflicts of interest disclosure. And just to boil it down, if you're going to do work with a vendor that your management company or manager has a financial interest in, you have to get competitive bids if the good or service exceeds $2,500. It just means you have to get more than one. You can't just go with the one recommended contractor. You would have to get bids if it's over 2,500. And all proposed activity that may be a conflict of interest has to be listed on all contracts and transactional documents, and attached to the board's meeting agenda, entered into the meeting minutes, etc. Just the statute wants to make sure that conflicts of interest are adequately disclosed, and you're not just moving forward with vendors that are owned by the management companies. SLAPP suits, strategic lawsuits against public participation. These occur when association owners, when the members are sued by individuals, business entities, or governmental entities for matters arising out of their appearance and presentation before the governmental entity on matters related to the condominium association. This just protects unit owners from retaliatory activity by the association against them when essentially they're just whistleblowing. And the association cannot spend funds in support of defamation, libel, tortious interference actions, or any other claim against a unit owner that's based on conduct described in this section. So if it's protected conduct, such as complaining to the division about the association's failure to provide access to official records, you can't fine the owner or threatening to bring actions against the owner for doing that, as long as it was in good faith and not for an improper purpose. A couple other miscellaneous changes that if you're an officer or director at a meeting and you have a quorum and you have to leave because of a conflict of interest or other issue where that director has an interest, it doesn't defeat the quorum. You still are fine to move forward with the vote. Another change dealt with the statute of limitations, statute of repose, that it does not begin to run until the unit owners have elected a majority of the members of the board, which is helpful. And then the last change we'll talk about may not pertain to anyone on the call, but this is a legislative fix to a case out of South Florida dealing with a condominium within a hotel building, where it was the case that was decided called into question that entire structure for condominium ownership because it was just inside of the building. It didn't touch the floor and it didn't have access to certain portions of the building, but there was a shared access and shared use agreement, and there was a problem with that based on certain language within the statute. So now that has been fixed legislatively. And that's what the condominium within a portion of the building deals with. So just to answer a few of the questions that are sitting out there, the MySafe Florida funding for raising a seawall to protect the association, I am not sure as to whether that would qualify. That would be the kind of thing to communicate with the state on and see if that's within the category and the buckets of information for which they will issue grants. And it is not a conflict of interest if a vendor is a condo unit owner. You can enter into contracts with owners within your community. There is a potential conflict of interest if a board member has a financial interest in the transaction. It doesn't mean you can't enter into those contracts, but there are certain disclosure requirements that you have to comply with before the association can enter into a contract with a board member's company. And there was another question about 1 and 2 story units you exempt from the reforms. If you are a 1 or 2 story unit condo building, the milestone inspection requirements, none of those apply to you because you are shorter. The milestone inspection requirements are applying to 3 or more habitable stories above ground, or 3 or more stories above ground, rather. So those would apply to you. Jennifer, I think that we answered all the questions, and that was the last bit of information that I had to share. So I'm happy to see if there are any other questions people want to pop into the chat, or if you have any questions, whether it's on HOA or condo, I'm happy to answer them.
I think one topic that we do get at the office a lot is about the debit card change.
Yeah. Pertaining to condos or HOAs.
I believe the debit card was for the HOAs, that they can no longer have a debit card, but they're allowed to have a credit card.
Yeah, and that was a few years ago.
Okay.
The debit card change, that was a few years ago. It wasn't part of this statute, as far as I'm aware, but credit cards are treated differently than debit cards.
Okay. Does anybody else have any questions for Aaron?
I think
we have a portal.
One just came in. Is the portal
Yeah.
process for ARCs used by Greenacre in compliance with the statute? Under another management company, our ARC approvals were done via email and later ratified in a board meeting. In 2022, the attorney indicated the approvals had to be done in an actual meeting, just not ratified in a meeting. That's correct. When Greenacre assumed management, we started using the portal and have been concerned as to why the portal is okay, even though it's not a board meeting. I will tell you that ARC applications can be submitted through the portal, but if you're going to be making decisions, especially if it's the board who's making decisions, then it needs to be during a board meeting. And ARC applications, statutorily, decisions made by the ARC have to be made during an open board meeting, an open committee meeting. So the ARC needs to meet in order to decide those items. So ratification is something to be used in case of emergency, not as a matter of practice. It's fine until it's not fine, right? And I use the word fine kind of, tongue in cheek, that it's not appropriate. And if an owner challenges you on that you're not allowing the members to attend the decision-making process for the ARC, they may oppose it. And if all you're doing is ratifying and rubber stamping something that's already been done, that can rub people the wrong way. So all should be done during open meetings.
Jim had some questions, though I don't see them in the chat, so he might be retyping them.
Okay, and I know that, so if this was the email that Lizzie had forwarded to me yesterday, I addressed a number of them with respect to fining, with respect to meeting notices and now website requirements. This is one of those lovely examples where there is not a whole lot of consistency between the different statutory sections. One section of 720 says this is how you post meeting notices. But you can adopt rules regarding how you post notices on your website and distribute notices in a different way. But now the statute says that meeting notices for membership meetings and boarding meetings must be posted on your website. So over notice. There's no problem with doing more than what you need to. You should put it on your website. And in that section that talks about board meeting notices and adoption of rules, it says, in addition to all the requirements above, you may adopt additional rules for additional posting of meeting notices on your website. But the advice that I am giving folks in connection with those issues where it's just not it's not incredibly clear. If you have a board meeting, post notice in the community, put it on your website. There's no harm in doing that. It means that no one can call anything into question.
Great. We also have two more questions in here. Are there any mentions in the new law pertaining to any changes in how CDDs operate as it pertains to those HOA changes?
Not that I'm aware of at this time, no.
Okay, and then Jim has a question about subsection 720.
And this, yeah, and that's the question I just answered.
Okay,
regarding notices. Yep. Anything else? Well, with nothing else, I want to thank you for your time and everyone's time. I know that it's cutting into everyone's dinner time with your family. These are important changes. There are a lot of them. And I appreciate all of your time. And as always, Jennifer, appreciate you inviting me to present.
Of course, we appreciate your time and we appreciate everybody attending, and have a nice evening.
You're welcome. Thank you so much.